Uh, Being together, I think, was very helpful and helped build collegiality among the commission members. So thank you, members of the commission. I wish you well as you do the hard work of the commission. It's been a privilege working with all of you. Thank you.
Thank you so much, Commissioner Dietzen, for your service to us as well. We'll miss you. We also have two other members who are leaving the commission. As I said, a lot happened in the interim between our last meeting and this one. Abby Honnold is a public member of the commission, and she holds a seat that represents an individual who has personally been the victim of a felony crime. She was a member for almost 2.5 years, appointed in 2019 by Governor Walz, and she had to step back. She was unable to be here today, but we will be sending her recognition of her service on the commission as well. And then last but certainly not least, Judge Kevin Mark, who represents the district court on the commission, will be leaving us as well. He's been a member of the commission for about 1.5 years. Having stepped in, I think, for Judge Lennon, I think was who you came in for. Judge Mark was appointed in 2020, in February of 2020, and served through July of 2021. And I am happy to say he's been newly elected as Chief Judge of the 1st Judicial District. But I'm happy to say that this is why he needs to leave the commission, because that comes with a lot of work as well. Commissioner Mark, would you like to say something?
Well, my remarks will be proportional to my tenure. Much of this tribute is for Justice Dietzen, and I shared with Justice Dietzen that was one of the pleasures, was getting to know him and other members in my time. I'll also echo his comments. It's a diverse group, and that's a strength to the commission, the different perspectives that are brought. And also, I agree with his comments on the staff and their ability to provide us so much pertinent information from a great many sources. I enjoyed my time. I could see in the first month of my duties as chief that it was just going to take more administrative time that would come away from the time I could, or take away from the time I could spend on the commission. I'm quite confident my successor, Judge Knudsen, will do a great job on the commission. So thank you all.
Thank you so much. Thanks for your service on the commission, and we will also be sending you a recognition of your time here as well. Not as fancy as the plaque that Dietzen gets, but you know, still good enough, right?
All right. Thank you.
All right. Thank you so much for Judge Mark and Justice Dietzen for joining us today. I want to make sure that we now take the time to introduce our new members. And because you both are new, I also want the rest of the commission to take the time to introduce ourselves to you so that we all know each other. So first we'll start with our two newest members, and then I'm just going to ask everyone to quickly go through and also introduce yourselves one more time so that we all have that baseline. And I'm going to start with to my right here with Justice Moore.
Well, thank you very much, Chair Mitchell. Hi, everybody. For those of you who don't know me, and I'm suspecting that's a good number of the members of the group, my name is Gordon Moore. I was appointed by Governor Walz to the Supreme Court, I guess a year ago, roughly a year ago. I replaced well, I took the seat of David Lillehog. I won't be arrogant enough to say that I replaced him, but I have been serving for about a year and have been amazed at the work that's done at the Supreme Court level. Prior to that, I was a district court judge way outstate in Nobles County, where I served for about 8.5 years. I was appointed by Governor Dayton to that position in 2012. Prior to that, I was a 3-term county attorney, city attorney in Worthington, and a private practitioner. And before that, I started here at the AG's office in the late 80s. So I guess I'm kind of a homecoming to come back to St. Paul. I am honored by the Chief Justice's confidence in appointing me to this position. I talked to her a lot about this before that appointment was made. I'm well aware of the work that was done by Justice Dietzen. He and I haven't had the chance to talk about it in person. We're going to be doing that soon, but I'm impressed to hear about the consensus building efforts that were part of his leadership here. And it's just a distinct privilege to be his successor. Again, I'm not going to be foolish enough to believe I'm replacing Justice Dietzen, but I'm at least his successor. Unfortunately, I have some familiarity with the sentencing guidelines, having been a district court judge and a county attorney. And so I hope to bring some of that perspective to my work here, and anxious to get to know everybody. Thank you, Chair Mitchell.
Cool. Thank you. Judge Knudsen.
Excuse me, Judge Knudsen, could you flip your microphone on?
Sorry. Thank you. There we go. You want me to start all over, right? No, I'm just kidding. I previously served on the Judicial Council for 6 years. I've served on the Board of Judicial Standards for 8 years, and so been involved in some of this extra judicial committees and whatnot. And I really look forward to serving on the Sentencing Guidelines Commission. As you think about the decisions that a district court judge makes in dealing with criminal sentencing, we rely a ton, of course, on the guidelines and the instructions that we get from the Sentencing Guidelines Commission. And I think I'll learn a lot. Even though I've served on the bench for 17 years, there's nothing like getting into the details as I'm starting to learn here, just briefly, than serving on the Sentencing Guidelines Commission. So I look forward to this adventure. And again, also thankful to the Chief Justice for this appointment and this opportunity to serve in this capacity. So.
All right, thank you. Commissioner Middlebrook, why don't you continue?
I'm Catherine Middlebrook. I'm the Chief Appellate Public Defender and representative of the Public Defender Agency.
Great. Let's see, Commissioner Ladd, would you introduce yourself?
I'm Kyra Ladd, and I'm the Wadena County Attorney, and I am the attorney representative on the commission, and I was appointed to the commission by Governor Walz in September of 2020.
Thank you. Commissioner Larkin.
Thank you. I'm Judge Larkin from the Court of Appeals. I started on the commission about 2 years ago. My practice experience is as a public defender in Hennepin County for 13 years, straight out of law school. Then I was a district court judge for 3 years in Wright County, chambered in Buffalo, and then was appointed to the Court of Appeals in 2008. I am the Supreme Court's designated representative from the Court of Appeals. I have a bit of experience working with our chair on other committees. I've been a member and chair of both the Rules of Criminal Procedure Committee, the committee that does juvenile delinquency rules, child protection rules. So my familiarity is most in criminal law and related issues, so I hope I bring a good background to the group.
Thank you. Commissioner Schnell.
Hello, welcome everyone. Paul Schnell. I'm currently have the honor of serving as the Commissioner of Corrections. And I've been in that role since January of 2019 and serve on the commission as the because of the designation, statutory designation of the commissioner as a member of the Sentencing Guidelines Commission. So welcome, and I both saddened to see Justice Deason and Judge Mark and others leave us, but look forward to working with all of you. Thank you.
Thanks. Before we keep going, Nate, is it possible to turn up the volume in this room? I'm just having a little trouble hearing some people sometimes. I'm not sure if anyone else is.
I would have to phone a friend on that, Madam Chair. I could
Maybe that's
try.
something you could work on over time. In the meantime, we'll keep going. Commissioner Hansi.
Good afternoon. I'm Commissioner Hunzi, Tanya Hunzi, and I was appointed by Governor Walz in beginning of 2019. I sit as a public member, also as a directly impacted person by the criminal justice system. I also work in policy, specifically mostly around women in incarceration. And so, awesome. Welcome.
Thank you. And Commissioner Estrada.
I'm Valerie Estrada. I have been appointed by Governor Dayton in 2016 and then reappointed by Governor Walz. I am the probation officer representative on the commission. It's been a great experience, and there is so much knowledge on this body that I'm constantly learning. Welcome.
Thank you. Let's see, I think I got all the commission members, but for the benefit of the new folks, I'd also like to introduce the staff as well. I see Ann Wall is online, so Ann, if you wouldn't mind introducing yourself. Maybe. There she is. Oh, I think you're muted.
All right. Hello again. My name is Ann Wall. I'm on the staff. I'm the senior member of the staff. I have been here since the end of 1986, no, beginning of 1986, and look forward to working with all of you.
She's very modest. She is the most knowledgeable, longest lived staff member that we have here at the commission. She really runs the data operations in terms of, figuring out the statistical analysis and all of that. She's great. And we're really lucky to have her. Is Jill online today at all, Nate, or is she not here today?
I would have to elevate her, which I can do.
Oh, it's okay. We don't have to. I mean, it'd be great if you could, because she's one of the key staff members too, but I don't want to take too much time. That's hard. Oh, there she is.
I think I've elevated her.
Hello, I'm here. Yes, I'm Jill Payne. I'm a research analyst, a senior research analyst as well. And I look forward to working with all of you. Thank you.
Also very modest. Jill is another key researcher here at the commission, and also really good with policy work. So someone that has been here for not as long as Anne, but quite a long time, and we are really lucky to have her. Linda is also here. Do you mind coming over to a microphone and saying hello?
My name is Linda McBrayer. I'm the management analyst. I've been with the commission for 20 years, last April, and my role is working with practitioners on applying the policies and also making sure that the wheels continue to turn for the agency, like paying bills and things like that. So thanks.
Excellent. Thanks. So one of the key trainers for the commission as well. And then we do have a couple of other staff that I think I'll let Nate introduce as well. And Nate, why don't you just make sure that everybody knows who you are?
Thanks. So I'm well, Katie Madland texted in to say she's fine if we just say hi on her behalf, but she's also part of the research team. And I wish I could say we had a couple more. We're working on that. We've had a vacancy since January in the research team. And due to a hiring freeze that just ended, we haven't had a chance to fill that. So we are going to be interviewing some folks next week, I think next week for that position, and hopefully we'll rectify that situation soon. But we've been frankly struggling to keep up. As I already mentioned, I've been in the service of the commission since 2014. Before that, I was an assistant Rice County attorney for roughly 15 years. And before that, I was on active duty in the Army. I continued on doing a concurrent military tour in the service in the reserves. So I just a few years ago retired as a reserve JAG officer. I was a military judge in my last assignment. So that's a little bit about me.
All right, thanks. So my point in making sure that we met the staff is that we are nothing without them behind us, because they are fantastic, and they put together the materials and help us analyze the policy options that we are trying to come up with. You know, we make the votes, but they make the votes happen. So I just wanted to make sure that you all had a chance to meet them as well. Okay, so let's move on. We have a pretty full agenda today. The next item of business is approval of the draft meeting minutes from July 22nd, 2021. And for that, I would entertain a motion to approve the minutes.
So moved.
I'm sorry, who said that?
Commissioner Estrada.
Commissioner Estrada makes the motion. Do we have a second? Commissioner Middlebrook seconds. Any discussion on the minutes? All right, hearing none, let's go ahead and vote on those.
To the Estrada motion to approve the minutes, to approve the July 22nd minutes, Estrada?
Yes.
Estrada, yes. Blakey? Blakey absent. Hansi?
Yes.
Hansi, yes. Knudsen?
I'll abstain since I wasn't present for that meeting.
Knudsen abstains. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
I will abstain as well, as I wasn't present for the meeting either.
Moore abstains. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 7 votes in favor, no votes opposed.
And with that, the minutes are approved. All right, thank you. Okay, so the last meeting we had in July was to actually do the initial rankings of the offenses that were passed during the legislative session, and to deal with other laws and changes that also might result in needed changes to the guidelines. So we did that in July, and then we had a public hearing on those changes. So the next order of business is to review that public hearing record, and I'm going to turn it over to Nate for that.
Thank you, Madam Chair. On Monday, August 2nd, 2021, the notice of public hearing was published in pages 105 through 106 of volume 46 of the Minnesota State Register, a copy of which is in your meeting materials. On the same day, the contents of the proposed modifications were posted on the Commission's website, and an email notice of public hearing was sent to persons who have signed up on the Commission's website to receive informational emails. Also copied, that notice is also copied in your meeting materials. Instructions for remote participation by telephone or interactive technology were also posted on the Commission's website at that time. No one was notified by United States Mail because there are no longer members of the public on the Commission's United States mailing list. Pursuant to the notice, the public hearing was conducted on September 1st, 2021 at 1 p.m. Pursuant to the notice, the hearing was conducted both in person in this room, State Capitol Room G3, and remotely by telephone or interactive technology. 1 Commission member, Chair Kelly Lynn Mitchell, participated in person. 5 Commission members participated by interactive technology, Vice Chair Estrada and Commissioners Hansi, Knudsen, Ladd, and Middlebrook. Staff member Nate Wrights attended the hearing in person, and staff members Linda McBrayer, Kathleen Madlin, and Jill Payne attended the hearing by telephone or interactive technology. No member of the public attended the hearing in person, and 3 members of the public attended the hearing by telephone or interactive technology. Instructions for contacting the agency to register to testify were provided to the public on the Commission's website and were reiterated by the chair at the hearing. No members of the public contacted the agency in advance of the public hearing requesting to testify, nor did any member of the public in attendance contact the agency during the public hearing requesting to testify. After the public hearing, the record remained open for 5 calendar days to accept written comments. The Commission received no written comments during this period. The Commission appears to have complied with all public notice and hearing requirements, Madam Chair, to permit it to take final action on the proposed modifications.
All right, thank you. So nobody showed up to the hearing. No one submitted comments following the hearing. So there may not be a need for a lot of discussion on the items that we've already decided on today. Certainly, if anyone has any further discussion that they'd like to go through today, we can do that. But my thought is that we'll take item 6 by letter. There's 3 letters there, A, B, and C. Nate will quickly remind us what falls into sort of each bucket, A, B, and C. And then I would entertain a motion for the full package under each of those sections as to whether or not we want to finally adopt those changes. So Nate, if you would start to lead us through that.
Thank you, Madam Chair. So I guess I would, so number A had to do with legislative amendments to crime laws affecting the sentencing guidelines in the 2021 first special session. So that was the June 2021 special session, which really is where almost all of the legislative work on crime laws occurred this year. So if you look on your materials on the notice of public hearing, on page 2 through 4, there's a table with 20 items on it, and essentially those 20 items are the items that are proposed to be modified in the sentencing guidelines in summary, and then of course the actual modifications themselves follow in great detail. I'm not planning on going through the detail. I'm not even planning on going through each of the modifications. Obviously, a number of them had to do with criminal sexual conduct. There were also some significant modifications having to do with first-degree assault, and particularly some new offenses and some new mandatory minimums that are incorporated in that. If I may, Madam Chair, I'd like to essentially brief by exception, and I'd like to talk about the 2 areas where the Commission made choices at the July meeting that were not part of the meeting materials that we presented to you. It wasn't a staff recommendation, if you will. So one was, and I'm not going to display the one on the screen, was to rank the new first-degree assault where there's either deadly force or a dangerous weapon used, and there's great bodily harm inflicted upon an official, and we're using the term official to mean the 4 various officials: peace officer, correction officer, police officer, and judge. I'm sorry, prosecutor or judge, that are listed in the statute. That was ranked at severity level 11 by the Commission, just as a reminder on that. I would like to just take a moment to show the sex offender grid, because that was another area where the Commission did not, I'm not by any way being critical by saying you didn't follow the staff recommendations. Obviously that's great, but we're just pointing that out because it wasn't something that was printed and you hadn't seen it until we sent out the public hearing notice. So try to pull that up this time. All right, so this is the document that I called Clean Grids in your meeting materials. The The change has to do with severity level H and severity level I. So what is displayed here is staff's attempt to capture the intent of the commission at the July meeting. So staff's understanding of the commission's intent at the July meeting was to essentially clone severity level H and create a new severity level I that's identical to severity level H. The existing severity level H would be changed. So that severity level I is going to apply to the same offenses that under the current sentencing guidelines apply to severity level H, which is to say failure to register as a predatory offender. So failure to register as a predatory offender is moved from H to I, and I is identical to the existing H. So what happens to the existing H? So H, as I said, is a clone of I, except that for the first 5 criminal histories, that's 0 through 4, the durations are shaded, which means it's a presumptive stay rather than a presumptive commit. Severity level I has no shaded squares, and the reason for that is by operation of statute, all failure to register as a predatory offender is a presumptive commit by operation of statute. There's a mandatory minimum of at least 1 year and a day in prison for failure to register as a predatory offender. That's why that whole row is unshaded. So the new severity level H applies to this new offense. The new offense is criminal sexual conduct in the 5th degree involving non-consensual sexual penetration. And that's an offense that the commission assigned to severity level H. One interesting aspect about this new offense that was discussed quite a bit at the commission's July meeting is the fact that it has a comparatively low statutory maximum. It has a 2-year statutory maximum for a first offense. So as a result, it didn't fit very well, frankly, anywhere on the sentencing guidelines grid. And the commission's choice was to put it at, again, severity level H, which is a clone of severity level I. So I'd like to call the commission's attention particularly to these last 2 unshaded squares where you see the number 24 6 times. So it's 24 is the center of the box, it's the top of the box, and it's the bottom of the box. Now that's an interesting, that's our best interpretation of what the commission's intent was at the time. What's interesting about that is there's not this statutorily required range of 15% below the presumptive sentence, 24 months, and 20% above the presumptive sentence of 24 months. The reason there's not that range is explained in this footnote, which was also something that the commission asked us to do when it made the motion at the July meeting. And the footnote explains for severity level H, all displayed durations, including the upper and lower ranges, are constrained by the statutory maximum criminal history scores above 4. So essentially, following the commission's intent to make H essentially a clone of what's now going to be I, the intended durations for these 2 boxes right below it, you can see all those durations exceed 24 months. So the commission's intended durations are essentially thwarted, if you will, by the statutory maximum. So that's why even the lower ends of the ranges are 24 months, because all durations, upper, lower, and center of the box, are constrained by the statutory maximum. That's really all I had to share on that. I'd be happy to discuss any questions about this particular issue or any of the items 1 through 20 or any of the other changes that are in the materials with respect to the legislature's action during the first special session.
Anyone have any questions about the grid? This is the first time that we've had a chance to see it in action. Okay. Hearing none, I would entertain a motion to approve this part of the package.
So moved.
Commissioner Schnell makes a motion to finally adopt. What would be the language of the motion, Nate?
So it would be a motion to finally adopt the proposed modifications in section A of the notice of public hearing.
Is that okay with you, Commissioner Schnell? Could you hear that?
That's exactly what I was going to say.
Okay, great. Do we have a second?
Larkin will second.
Commissioner Larkin seconds. Any discussion on the motion? Okay, hearing none. Nate, would you please call the roll?
To the Schnell motion to finally adopt the proposed modifications in section A of the notice of public hearing, proposed amendments to the Minnesota Sentencing Guidelines and Commentary dated August 2nd, 2021. Estrada?
Yes.
Estrada, yes. Blakey? Blakey, absent. Hansi?
Yes.
Hansi, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Schnell?
Yes.
Schnell, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right, let's move on to part B. If Nate, could you please remind us what's in there?
So, Madam Chair, as I said, the legislature wasn't terribly productive, relatively speaking, in its regular session. Part B relates to really the only change that we found that directly affects the guidelines, which is that they took an existing offense that's identity theft in subdivision 3(5) and divided it up, put most of it in subdivision 3(5) and created the part having to do with child pornography, moved that into a separate subdivision 3(6). So these are just really conforming changes. There's no policy change resulting from the changes in section B.
That's right. I forgot that section B was so tiny. So let's also remind us what's in section C, and maybe we could handle both together.
Thank you, Madam Chair. Section C is really a legislative change that occurred a few years ago, having to do with a renumbering of a statute in assault in the 4th degree, having to do with the conditional release provision. It got moved from 3A parens D into 3A parens E, and this is just catching up.
All right. So I would entertain a motion to adopt the changes in section C and B.
Ladd would so move.
Commissioner Ladd makes that motion. Do we have a second? And Commissioner Middlebrook seconds. Any discussion on the motion? Okay, hearing none. Nate, if you wouldn't mind reading the roll, please.
To the Ladd motion to adopt the guidelines changes in sections B and C of the same document. Estrada?
Yes.
Estrada, yes. Blakey? Blakey, absent. Hansi?
Yes.
Hansi, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right. So just as a reminder, the goal was to put this set of guidelines out by September 15th. Is that correct?
That's right, Madam Chair. Yep, we're pretty much done. We obviously, it would have been harder if there had been the votes came in a little differently than they came in today, but yeah, we should have that done so that these should be published next week.
All right. Thank you very much. Thanks to the commission members for getting through that pretty quickly. So now we'll move on to some meatier items. Item number 7 is partial points in criminal history we've had a working group trying to deal with this issue over the summer. Nate is going to take us through, we're going to start by having Nate take us through sort of the chronology of this issue and how we got here today, just to give you an overview. Then we also have Professor Fraze joining us today, and he's going to talk a little bit about custody status and its use in other states. And then we have the proposals or the ideas that have been brought forth by the working group, and we'll spend some time talking about those towards the end. So this is sort of a long discussion on the partial points, and I will hand it over to Nate to start us off.
Thank you, Madam Chair. Members, you have in your materials a document called A Brief Chronology of the Custody Status Point. And this really goes into a couple of other issues, one of which we'll be talking about later, which has to do with the severe violent offender list, because it is in some ways related to the half custody status point. And the other has to do with just partial points in general and how the commission has treated those. So going way back to 1980, when the first sentencing guidelines in the nation were promulgated on May 1st, there were no partial points. Everything was a whole number. Every felony was worth 1 point. Custody status was worth 1 point. Misdemeanors and juveniles, they operated in terms of like each juvenile offense was not worth 1 point and each misdemeanor was not worth 1 point. But those factors, or they called them items originally, but those items were designed in such a way that it didn't count unless there were enough of them accumulated to equal a point. So there were only whole numbers in the beginning of the guidelines. And then in 1989, the commission changed the guidelines to reflect the fact that not every felony should be worth the same amount in criminal history. Murder should not be worth, writing a bad check. So the commission weighted felonies. So some felonies were worth a half point, full point, point and a half, 2 points. The commentary, it wasn't in the guidelines, but the commentary said no partial points are given. So a person with less than a full point is not given that point. So 2.5 points is equal to 2 points, essentially creating a rounding down rule in the commentary, although that language wasn't used at the time. Then in 2006, so 7 years later, the commission moved that from the commentary. I was told this might have been in response to a court case that said, hey, the commentary is just commentary. That's not the guidelines. The commission's like sort of did a movement of commentary rules into the guidelines themselves. Again, that no partial points are given was stated. And then in 2012, as part of a larger rewrite, the felony point rounding rule was further clarified. If the sum of the weights results in a partial point, the point value must be rounded down to the nearest whole number. So that's sort of the history, I guess, before I got there. And then in August of 2015, that's when a conversation started between the commission and the family of a murder victim, Anna Ray Shunk, regarding this was a victim who was whose murderer had a lengthy violent criminal history, was sentenced to prison, got out, and then committed the murder. And the family felt that there should have been a longer initial sentence there. So that discussion went on. At the same time, so Justice Dietzen talked about the drug changes that occurred in 2015 and led to some more serious drug changes that occurred in 2016. So after those drug changes, the commission's next major project was to look at the criminal history score and just see if there were things about the criminal history score that could be improved or reformed. And that was a lengthy process that really lasted a couple of years. And then throughout 2018, it culminated in some consensus building that there needed to be some changes. And there's a lengthy memo that you have in your materials that was a memorandum to stakeholders that I think is representative of some of the ideas that the commission was thinking about. Not necessarily that any of those had garnered consensus, but those were so the commission was open to thinking very seriously about major changes to the criminal history score. And then finally, in 2018, the commission unanimously adopted a package of modifications. Again, this ties into our farewell to Justice Dietzen, because Justice Dietzen seemed to be really interested in moving forward on a consensus basis with these changes. And it did turn out to be a unanimous package. And I say package because the package included not just the criminal history score changes, but also included these repeat severe violent offender, the repeat severe violent offender modifier that's currently in the sentencing guidelines. And these were all adopted at the same time. One of the changes that the commission adopted, and actually I have a slide that I'm going to show you later that maybe I should show you now, but it shows essentially what those, I think it will pop that up right now. So there's a lot of interwoven themes here in today's meeting. So I'm going to share with you now a slide from the Robinette presentation later on. So what this slide illustrates, it's essentially a summary of all of the changes to the criminal history score that the commission adopted in December of 2018. So most of the changes, now there are 4 criminal history score components. As I said, there were 4 in 1980 and there's still 4 today. Most of the changes had to do with the custody status point. There were some significant changes to the decay factor. And these were kind of on the lines of thinking it wasn't really fair that some people, it took longer for their offenses to decay because they were never sent to prison. They were only put on probation. And that seemed like a head scratcher to the commission. Why should somebody have an offense take longer to decay because they were never sent to prison? So essentially rectifying things like that's really what this new custody status half point, I would say, is sort of in that family of just trying to make the guidelines a little more reasonable. In fact, the excerpt of Professor Frase's book talks about this fact, that is it really fair that a custody status point should be worth more in criminal history than the offense itself? And that was what the commission was trying to rectify by creating this new half point, because all felonies were worth a full point. The custody status for a felony was worth a full point, even if the felony itself was only worth a half a point. In fact, custody status for a qualifying misdemeanor or gross misdemeanor is worth a full point, even though the misdemeanor or gross misdemeanor would not be worth anything close to a full point. So committing the crime in some cases was more serious than, was less serious in terms of criminal history than the fact that you were on probation for having committed the crime. So that's what the commission was trying to rectify by creating the half point in 2018, which went into effect in 2019. So that was all well and good. But what staff and all, this is where I get to eat crow. And I don't like the taste of crow, but I did not catch the fact that there was no rounding rule that was generally applicable. The only rounding rule in the sentencing guidelines was that rounding rule that was created for felony points. So as a result, the rounding rule didn't apply to the half point, which is what we had assumed. It's how we had Department of Corrections programmed the electronic worksheet system. We assumed that everything got added together and then rounded, but that's just not how the guidelines read. And that was brought to our attention a year after the guidelines took effect in August of 2020. We immediately, we being the staff, brought it to the commission's attention in September of 2020 and asked the commission to take some action. And in October of 2020, the commission did take action. The commission preliminarily adopted a proposal subject to public hearing and final adoption to move the rounding rule from the felony section to the main criminal history score section. And that was not unanimously adopted by the commission. I think Commissioner Middlebrook may have abstained, but all commission members who were there, I think, voted for that. And then in December, there was a public hearing, and at the public hearing, nobody testified about the rounding rule at that time, but then we had a meeting right after the public hearing, which, and at that meeting, we discussed a legislative proposal to have the legislature give the change to the rounding rule immediate effect. And at that point, some of the commission members discussed some reservations about the rounding rule itself and about whether this was appropriate for the half point. And then we got some public comment in writing after the hearing, still within the written comment period, expressing opposition to the rounding rule amendment, or alternatively making explicit the policy of ignoring that 1/2 custody status point. What that means is, so if what the judge who wrote to us in August had proposed to do was essentially round down the felony point and then round down the half a felony point and then round down again the half a custody status point. So sort of a double rounding down. And the effect of that, if you were always to round down the custody status point, would be to nullify the commission's decision to give that half a custody status point some weight, not as much weight, but some weight. But that would always be giving it no weight. So then in January, the commission met to take final action on the proposal that it adopted in October. It unanimously voted against taking that final action. So there was no change to the rounding rule made. Instead, the commission expressed interest in resolving the problem. So members acknowledged that there was a problem, that it needed to be resolved, but they didn't like this particular resolution that staff had proposed. So then in February and March, the chair convened a 4-member working group to develop a proposal to resolve the problem of partial points in criminal history. Because as by a plain reading of the guidelines, there is the possibility now of a partial point in criminal history, which is a problem because the horizontal axis of the grids, which is the criminal history score, doesn't contain any partial points. So we don't know what to tell people as far as what is the presumptive sentence when there's a partial point in criminal history. We developed a staff memo to that effect, which the commission reviewed, and that's been put out to the field. It's a little frustrating, I think, for the field because it very clearly says how to calculate the correct criminal history, but it doesn't say what the resulting presumptive sentence is, which is the whole point. So that's where we're at. I won't. I think you can catch us up to speed from here as far as what's happened to this working group that you convened, Chair Mitchell, who was on it, and that sort of thing.
All right, thank you. Yep, so the working group met over the summer. In a little bit, we will tell you, we'll go over the ideas that we're putting forth. The working group did not reach consensus on an idea, so I just want to make that very clear as we come into this discussion. I actually think we had a really great process. We had really great conversations. It really functioned like a workshop all summer long, and I really appreciate the other members for that open and candid conversation. The other members were Commissioner Larkin, Commissioner Ladd, and Commissioner Estrada. But at the end of the day, we did come up with several different options, but no consensus on whether the commission should adopt any one of those options or maybe even pick something that's not even on that list. But we are the time is ticking, and we've reached a point in the year where, based on our rules, we need to have discussions at the commission level for several months before we can pass a policy. And I think it's really imperative that we buckle down and figure this out as a commission before December, with the goal of having an option put to a public hearing in December so that we can solve this for the field. I happened to go to a conference in another state this summer, and probation director, who will not be named here today, from somewhere in Minnesota, was also at this conference and took the time to track me down and say, I don't care what you do, but do something. Like, this is ridiculous. And I agree. I agree. It's confusing. Right now, all the onus is on the court. Basically, our advice was, make the judge aware of the situation, and that at the end of the day, the judge has the ability to make the call on what the presumptive sentence is. And so that's how the state's been functioning for the past year. So we do need to get this resolved. And I just want to, make that very clear to the commission that my goal for all of us is to work through this and get to the end. But I do think today we should spend a little bit of time, thinking more about the purpose of custody status, what's it for. At one particular meeting, which Commissioner Ladd was unable to attend, Commissioner Estrada and Commissioner Larkin and I really had like a whole discussion on purposes of punishment and how the custody status point played a role in that. And it was really a great discussion. And, we both sat there and we all sat there and we were like, we need this discussion at the commission level. We need to all have this discussion at the commission level. So I'm hoping we can achieve that in part today. And to help us, get into that frame, we've invited Professor Richard Fraze from the University of Minnesota Law School. He's an expert on sentencing guidelines. That's his life's work is scholarship relating to sentencing guidelines. So there's no better expert than Professor Fraze. He's going to talk to us today about, sort of what role custody status plays, how it's used in other states, and give us a little bit of priming for this discussion about the role that we think it should take as a commission today. So with that, I will turn it over to Professor Fraze.
Okay, thank you, Madam Chair. And I assume you can hear me. I'm not used to WebEx. I use Zoom, but somebody would be hollering if my mouth was moving and you couldn't.
We can hear you for sure, definitely.
Thank you for giving me the opportunity to address you. I realize that time is short. I was asked to address a couple of things, and I'll try. A lot of what I'll touch on is in the excerpt from the book that was provided, the 8-page section in Paying for the Past that specifically deals with custody status points in criminal history or enhancements in guideline systems. So I guess I will sort of touch on the three purposes of punishment that arguably justify custody status enhancement of some kind. But then the question is always what kind and how much. But at least we have to start with what purposes they seem to serve. So it's often asserted that a person who commits a crime while in custody status is more culpable than that person committing the same crime if they weren't in custody status. Well, why is that? I mean, culpability, a paradigm of culpability is that a person who commits a crime purposefully is more culpable, causes some harm purposefully, is more culpable than if they cause the same harm recklessly or with criminal negligence. So that's the sort of paradigm of a difference of culpability. And so there are various theories for why somebody in custody status is more culpable. I mean, they're sort of defying the court in some way, violating some sense of trust that was shown when they were put on supervision. Less clear when they're committing the crime while they're in custody, in prison. That's not real. I suppose you could say it's a trust. Everyone has the duty to obey the law, but to say there's greater culpability means that we're saying that this makes the current crime more blameworthy, more culpable than without the custody status. And again, how much more? We have, there are ranges that judges have, 20% up above the presumptive sentence, within which judges could consider this without a departure. One of the reform options would be to fold it into departure as an aggravating circumstance. So how much more culpable? And I think there would probably be fairly broad consensus that, and the commission decided in 2018 that at a minimum, custody status should not add more to the criminal history than the triggering offense, which I think is called in your documents the custody status offense. It's the crime for which the offender was in custody status. And it clearly, if that only counts a half point or isn't counted at all because it's a misdemeanor, how can we count custody status a full point? So that is problematic. I think there are lots of distinctions that could be made, one of which is what we call in the book patterning. I think intuitively we might say if somebody's on probation for assault, and then while on probation for assault, they commit another assault, that somehow that's a particularly clear case of defiance and lack of self-control. But custody status isn't limited to those cases. So anyway, there is, as has been pointed out, there's a double counting that might exceed what a person deserves in terms of culpability. You can actually get a kind of triple counting because there are other penalties for custody status violation besides the custody status point. If he's on supervision, he can be revoked to prison. If he's in prison, he can lose privileges or good time. If he's in escape status, he's probably going to get consecutive sentence to his old sentence. So there are other penalties. The custody status point, because it's an automatic criminal history factor, does not take into account whether there are other penalties and if they were imposed or not imposed. It's just across the board automatic thing. So anyway, there are some issues about just deserts, retribution, and the custody status point. Deterrence. It's thought that adding the custody status enhancement gives these offenders an additional incentive not to commit crimes while they're in that custody status. Again, I guess you have to, first of all, ask, why do we think we need that additional deterrence for those people at that time and not after he's off probation? Doesn't he need the deterrence more at that point because he doesn't have these other penalties? But nevertheless, it's thought that these people need the extra incentive of the custody status enhancement. There's no research on deterrence and custody status enhancements. There is quite a bit of research on what's called marginal deterrence, the effect, the crime reducing effect either on this offender or on offenders generally that you get from a modest increase in penalties. And I think that the bottom line of that research is it's difficult to find any marginal deterrent effect, and that's partly because penalties are already more severe, offenders aren't thinking about the future and about the penalties, all kinds of things, assumptions of deterrence, rational actor, alternatives to crime, all kinds of things that don't seem to actually apply in the real world. So certainty of punishment is probably consistently found to be a more deterrent factor. So, and again, there are other penalties for each of these custody status violations besides adding to criminal history or even doing an upward departure. So that's deterrence. Incapacitation or public safety, it surely seems intuitively correct that somebody who couldn't obey the law when he was under supervision or in custody is more likely to commit future crimes. There's limited research on that, some of it done here and is cited in Julia Laskarinsky's presentations to the commission, which found that the added predictive power of a criminal history score with custody status point versus the same score without adding custody status point added about 1% to the predictive power of the criminal history score. The U.S. Sentencing Commission also found similar modest predictive power. The state of Virginia has a low risk assessment tool. It's basically used to justify downward dispositional departure, probation for somebody who was otherwise recommended for prison, and that one of the factors there is not on custody status, but they don't apply it. They did a lot of research on prediction of risk, and they have a high risk scale for sex offenders, does not include custody status. So apparently they didn't think it was a very strong predictive factor, but it adds something. And again, the question is, how much should we enhance for custody status, and should it be done by an automatic formula, or should it be done with more flexibility? And we have some flexibility now with the waiver provision, but it has its limitations. I guess one other thing the last thing I would add to the sort of purposes point is that besides those traditional purposes of punishment, there are some important policy considerations that the Commission has always recognized, and that bear on how you shape a particular guidelines rule. And so those two policies are simplicity and parsimony. Parsimony, also known as the least restrictive alternative. So simplicity, the Guidelines Commission said when it constructed the first criminal history score, one of its the four considerations was simplicity of application. That way you have fewer errors, more consistency. There's also more transparency. People can understand the rules if they're not too complicated. And we want people to understand the rules, especially offenders, but also the public generally. Parsimony, the least restrictive alternative, it's recognized in two places in the guidelines. One is on page 1, when one of the guiding principles is the least restrictive alternative that will achieve our purposes. And back in the conditions of probation, state sentences, you see that principle stated again. And it's a fundamental practical consideration. Utilitarian philosophers have long said that you shouldn't spend more or impose more punishment than you need to. So that's just a basic utilitarian consideration. But it's also a retributive concept in the sense that just as we have a proof beyond reasonable doubt rule that says it's better to err on the side of too few convictions than too many, because we know we're going to make mistakes. And convicting somebody, punishing of something they didn't do, or punishing them more than they deserve is a worse error than the opposite kind of error. So parsimony is consistent with those kinds of principles as well. And I think it was because of both simplicity and parsimony that the Commission decided we're not going to have partial points. We're not going to have partial misdemeanor points or juvenile points. And when they went to felony weighting, we're not going to have partial felony points. It was keep it simple and round down, essentially. So those are broad principles that the Commission has always followed. Let me briefly just underscore as a second major category here our survey of what other guideline systems do. In the book, we identify a total of 19 jurisdictions that have something that we could call guidelines, and Minnesota is one of 11 jurisdictions in which custody status is in something that looks like a criminal history score. But those 11 jurisdictions differ quite a bit in how they count custody status and how much weight it has. So I think, as was pointed out, in North Carolina, custody status always gets 1/2 point. Felonies get at least 2 points, 2, 4, 6, 9, and 10, I think. So custody status counts less, and sometimes far less than a triggering offense in that state. So there's a question again of how much. There are 2 jurisdictions that have no reference to custody status at all in their guidelines, those Oregon and Pennsylvania. And then there's, I guess, 6 other jurisdictions that are, kind of compromised position. 5 of them recognize it as an aggravating factor, so basis for upward departure. One of them, District of Columbia, just recommends consecutive sentences for somebody committing a crime in custody status. So there's a lot of variation out there. There is a majority rule that you do count custody status, but a lot of variation in how it's applied. And I guess what I'll end on for now, and I guess I could talk for a long time, but you may have questions that will bring out other things I might want to say. I just want to sort of, as a footnote to the chronology, take us back to the original criminal history score and the 4 components that were in that score. Custody status was put in that score because the Commission was directed to take existing sentencing and releasing practices into substantial consideration. So they researched what judges had been doing in terms of in-out decisions, prison, no prison, and what the parole board had been doing, corrections board had been doing, and deciding how long people have to stay in prison. And they found that at least as to judges' decisions, custody status was an important factor, the next most important factor after the number of prior felony convictions. And I haven't tried to unpack that research. I'm guessing that it's consistent with something I found years ago, which is that when judges in Minnesota were trying to decide whether to issue a downward dispositional departure, find the defendant particularly amenable to probation, they were, even if everything pointed in that direction, if the offender had custody status, the offender was much less likely to get a downward dispositional departure. So it was affecting the dispositional decision. As to duration, my understanding is the parole board had a risk prediction scale that was kind of analogous to the criminal history scale. It was the horizontal axis of the grid for releasing offenders, and it did not include custody status. It did include 2 or more prior violations of adult probation or adult parole. So that could be a custody status case, but it would require 2 of them, not just this case. And of course, somebody who was not in custody status could still trigger that rule. So the custody status came from prior judicial practice, but it was applied to enhance durations as well as in-out decisions. The commission did all this relatively quickly. After the commission was fully staffed in late 1978, it had about a year to do all of this work that nobody had ever done before at a statewide level. So they were really short of time and resources on a lot of things. They did the best they could. And I think that what I'll end on is the point that now after 40 years of experience with the original criminal history score and other factors and attempts to tweak it, it's a good occasion to take another look at these issues with more data and more experience, something commissions should do regularly. And this commission has done. Justice Dietzen's memo recounts the substantial effort that went into taking another look at criminal history. Pennsylvania Guidelines Commission right now is doing its second comprehensive review of their guidelines. They did another one in the early 90s. And my understanding is that one of the things they're going to make a lot of changes on is criminal history. Now, they don't even have a custody status point, so I don't think they're going to add it. But in any case, it's looking carefully at what you're doing, why you're doing it, and what the consequences are, is something that a guidance commission should do regularly, as it's one of the reasons we have sentencing commissions. So that's enough.
Thank you, Professor Fraze. And thank you for sort of framing it that way in the end. You're right that this is a technical problem, but it gives us an opportunity to rethink and take a deeper look at why do we have criminal custody status in the first place. But I want to open it up do any commission members have questions for Professor Fraze? Commissioner Larkin, I see your hand up.
I do. Just one quick question. I read the report, the memo that Justice Dietzen prepared when the commission looked at changing the way it counts custody status. And one of the options that was considered and rejected was eliminating the custody point. And I wonder, do we have any better information now than we did then on any of these options?
I'm not sure that we do, although I don't know, given that he listed a bunch of options, and when I was looking at the 4 proposals that you now have, and some of them have multiple things embedded in them, so you could say that there are actually 4 aspects of the first proposal, I think, that wouldn't necessarily have to be joined together. There's a lot of different possibilities here, and I know that your subcommittee has been working on all of those things. I don't know whether, I mean, at the time in 2018, there was a lot of attention being given to the serious violent offender provision and the problem of custody status counting more than the triggering offense. And I wasn't privy to it. I guess the question would be, how much consideration was given either by a committee or by the whole commission to other ways of doing this, and the underlying questions of how do we justify this as a formal criminal history point.
Thank you.
And I think that if we do have a couple of commission members who were on the commission at the time, so as we continue the discussion today, I'm going to invite them to make any comments that they might want to make related to that topic. But before we do that, is there anyone else who has a question for Professor Fraze? Okay, seeing none, I have one. I always do. You guys know I always have questions. Professor Fraze, you referenced sort of the fact that this commission had to consider prior practice. When you were looking back on the record of sort of how custody status came into the criminal history point, did you find any information on what the original commission thought was the purpose of custody status? You went through some purposes of punishment earlier, but did you find anything on what they thought at the time?
Well, no, I mean, and I've been sort of revisiting that recently, I guess in preparation for this meeting and your discussion. In later years, in the 1984 report, the 3-year evaluation, there are statements about what purposes of punishment justify criminal history enhancements. There isn't anything specific to custody status there. Dale Parent, the first executive director, wrote a book in the mid-'80s that was published in early 1988, in which he just asserts that people who commit crimes in custody status are more culpable. But what was the commission actually thinking in 1979? If you look at, again, I made reference to the factors that the commission considered in devising its original criminal history score, one of which was simple to use and therefore less prone to error. The other 3 were consistency with current sentencing and releasing decisions. As I said, custody status was part of the sentencing in-out decision, but wasn't in any direct way part of the releasing decision. Another criterion is that anything in the score has to be based on objective and readily available records. And finally, nothing in the score should rely on social or economic status variables. There's nothing in that list or in anything else in this basic report in January of 1980 about the purposes of punishment. And I think there was, Dale Parent does say elsewhere in his book that there was a lack of consensus on the commission and out in the field on whether any kind of criminal history can be justified on retributive grounds. Some people said, yeah, it's at least a modest increment of culpability, and other people said, no, just deserts is about the harm and culpability of the crime you committed, and that book is closed at that point. Nothing can happens later is relevant, and custody status, I guess some of them anyway would say it's really doesn't have to do with the harm of the offense and isn't closely enough connected to culpability for that crime in the way that mens rea, intent, and purpose are. So there was no published consensus on purposes of punishment and criminal history generally, let alone for custody status itself. So I guess the answer is, I guess one last thing I'll add, Dale Parent toward the end of his book says, we had to do this really fast, and a commission should revisit a bunch of things. And one of the things he tees up for that is to try to find a more coherent basis for criminal history enhancements. which again suggests that he didn't really feel that they had nailed that down in the first round.
Madam Chair, if I could.
Commissioner Schnell.
Professor, are you aware of any kind of data that supports a clear and effective penal objective for a custody status point? I'm gathering not, based on a lot of the things that you were talking about tend to be more philosophical than practical, but I just wanted to ask that. If you're aware of any of that data.
I guess I'm wondering if you could give an example of something else that we haven't already mentioned.
Well, is there anything that you're aware of that suggests that we are, that there's, that supports the fact that there's an effective outcome based upon the use of custody status? In other words, you talked about things like deterrence, mentioned that. Are you aware of any data that would support the use of custody status as a?
It sounds like you're saying, in any case, something that I didn't touch on, but should have, is, could we say, I didn't talk about rehabilitation and all the variations on that in the community, in prison. So the argument, I guess, would be, and it's parallel somewhat to the incapacitation argument, but that one, because they both posit somebody who has, crime causing problems and that need to be addressed and to help them not commit crimes in the future. And so they're higher risk, and incapacitation says get them off the street for longer, and rehabilitation says, well, we're going to need longer to work with this person. So then we'd be asking, well, does a longer term in prison that we get from adding custody status enhancement, or the longer term or more intense supervision that we might get if he has at least more potential time hanging over his head, is there a payoff in terms of those people? And I mean, of course, it's devilishly tricky, because you can't do a scientific experiment where you randomly vary the factor in question. So you have to kind of try to tease out causation from all kinds of variables. And I'm not aware that anybody's done that. I do think that there's pretty considerable evidence that that very long prison terms, if they get even longer, can be counterproductive, in the sense that after you take out aging, which is going to happen anyway, this is somebody who isn't any better as a citizen than when they went in, and it might very well be worse. But certainly, I think one of the reasons that research is so inconclusive, it's so hard to tease out the people who were benefited from the people who were made worse, and the two effects could just cancel each other out. So I wish we knew the answer to your question.
Thank you. That's very helpful.
Commissioner Larkin.
Thank you. Professor Fraser, I appreciate your comments that the initial guidelines were created in a rush, but I also see from your work, which I very much appreciate, that some form of enhancement based on the fact that offender was in some sort of custody status when he or she committed the current offense has always been the law in Minnesota. It's been in the guidelines since the beginning. It was part of Minnesota common law. It's part of the law in other jurisdictions, federal, other countries. So this isn't something new. And I appreciate that it's important to study these policies and understand them and revisit them. But what I'm struggling with is whether the commission just did this a few years ago, and whether we have any new information that warrants a change in the form of eliminating custody status as a factor in sentencing. And I say that because in looking at Justice Dietzen's memo to stakeholders from August 2018, he explains that from 2017 to 2018, the Guidelines Commission conducted a comprehensive 8-part review of the various components. During that, they had presentation, we're getting trends from staff, and also presentation from the Robinette Institute of Criminal Law and Criminal Justice regarding its two-phase study of Minnesota's criminal history score. And that led to discussions about what's the purpose of the criminal history score. Is it recidivism? Does it include retribution, deterrence, public safety? How is success or failure measured? It looks like the first possible modification the commission considered was eliminating the custody status point for all offenders. And we have information regarding what it decided and why. I'm looking at public comments that were submitted in response to this memo that then Chair Dietzen set out. We have one from former Judge Warnick, who I think we all recognize as an expert in this area. He presented a paper to the commission in support of eliminating the custody status point, and he cited your work from the Criminal History Enhancement Sourcebook. We had comments from the director of Hennepin County's Department of Community Corrections, who also supported on behalf of the department eliminating the custody status point. So I guess where I'm left is feeling like this was studied just a couple of years ago. And before we open the door to this discussion again, what I'd like to again ask, since we have you here, is what new information do we have that we didn't have in 2018 when the commission rejected elimination of the custody status point as a proposal that was on the table?
Commissioner Larkin, before you jump in there, Professor Fraze, I do want to actually say there was no vote on the record that the commission ever rejected the removing the custody status point as a potential solution. I think it just wasn't the one that was worked up, but we have two members here who were on the commission at the time. So I think it would be appropriate for them to respond to that, to talk more about maybe what was going on at the time.
And Madam Chair, if I may, I'm sorry, I didn't mean to imply that it was rejected. I just see that it was considered, and instead of going forward with that proposal, the commission decided on the half-point proposal that we have today. So I apologize if I suggested that it was something was rejected. It was just something that was looked at and wasn't pursued.
Great, noted. I don't know if Commissioner Estrada or Commissioner Middlebrook, I think you were the two that were on the commission at the time. Am I correct in that? Did either of you want to make a comment? Commissioner Middlebrook.
Thank you, Madam Chair. Yeah, I was on the commission with Commissioner Estrada at the time that we did all this study. With regard to any new information, I think that there is we have additional information than what we had then. The other thing that was going on with this study is there was this whole package that we were looking at, and I think Justice Dietzen pointed out that it was really, there was a lot of compromising going on, and to reach a consensus on some of the different provisions that were in there, the policy changes. And so, there were commission members that supported the elimination of custody status. There were commission members that spoke against it, and we went through all of them, and it was really, I think it came down to a compromise, but we also didn't have some of the information that went way back to the history of the first guidelines and how custody status even became part of the criminal history. That is new information. We have much more, I think, information on the recidivism. We also have a new situation, that everyone is much more aware of, trying to reduce disparities and trying to, not necessarily increase sentences for all offenders, but to look at where those need to be identified. And so I think that there are different views that have come in and different opinions, and Professor Fraze has been, just an incredible resource on this. And I think the excerpt from his book, along with the rest of his book, has really enlightened a lot of us about history and where some of these components, whether they should be included and whether we really should look at all these to try to make things better, make it more simple, make it more fair overall. So I think that that's what I recall from the discussion back then, if that's helpful.
Okay. Any other comments there? Commissioner Estrada, did you want to say anything or?
That is also my recollection. I also just want to point out that part of that conversation and really looking at why we're looking at custody status point and what is the purpose, why are we doing this, is really recognizing that there is a fundamental problem with even noting what custody status is. You know, custody status is not the same around the state. There are people who are placed on probation to the court who are not provided a probation officer and given services. There are people who are living in small towns that do not have resources as easily available to them to get into programming first. And are we doing a disservice to people by continuing to punish people when we're not providing or there isn't, and I say we as in probation department because I work in that arena, but providing a disservice for not giving resources so that they're not committing new offenses, right? If you have somebody who's on for probation to the courts for a drug offense and they have a drug addiction and they're never provided any resources, are we really going to be surprised that they get another drug offense? And are we now going to continue to punish them? So I think it's important to kind of keep in mind that as Dr. Fraze noted, you know, culpability, purposely. When I think about those things, I think about all of the clients that are on supervision that don't have a one-on-one probation officer. I think about all the clients that do not have access to culturally specific services. I think about all the clients that do live in small towns around Minnesota where there's not a lot of services. So I just want to add that that was a huge part of our conversation too in why we were looking at this custody status and does it do more harm than good?
Thank you. Commissioner Larkin, I'll let you speak in just a moment. First, I just wanted to say, Professor Fraze, you're off the hook for questions, but I hope that you will stick around because we're gonna talk about these proposals specifically. And you know, at certain points, you might have some thoughts that might be helpful to us, and I think we would all welcome those as we continue to talk through. So I'm gonna invite you to stick around and continue with us through the rest of the meeting or through this part.
Just as a guideline for me, because we're doing guidelines here, I missed the beginning of the meeting, and can you clarify how long the meeting is? Because I'm probably going to shut up if you've got less than an hour to go.
Yeah, we do. The meeting goes till 3:30.
Yeah. Okay.
All right. But Commissioner Larkin, and then Commissioner Estrada. So if you will all indulge me for just a little bit, I do like to think about theory. I do think it's important for us to think about why we're doing something and to sort of think about the underlying purpose of the rules and the policies that we put in place. So I was hoping that before we get to the really talking about what the proposals are today, we could maybe just have a very short discussion. I'm interested to hear from commission members if anyone's willing to talk today. You know, what sort of purpose do you see custody status serving? And if we were to retain it, what would be the sort of rationale for retaining it? Or if you don't think we should retain it, what's the rationale for not retaining it? I'm actually curious if anyone on the commission is sort of willing to talk at a more theoretical level at this point, and then we can talk about the specific proposals and what they would do and whether they would fulfill those purposes. I'm just trying to connect the dots for all of us so we think about what policy we really want to achieve the goals that we're after. Commissioner Larkin, I saw your hand up.
Yeah, I mean, for me, I think it's deterrence. I think it's, you know, retribution. I think it's holding people accountable. I mean, the notion that you've committed a crime, you're on probation, the obligation is to prove you'll be law-abiding, and you don't do it and you commit another crime, it has always been the case that warrants an additional consequence. And I mean, in terms of the narrative, I appreciate probation's acknowledgement that they are oftentimes not able to provide all of the services that they would like to. But as somebody who is a public defender for 13, I know that there are lots of people who are on probation who have the services available to them and don't use them. So I think we need to be careful in not just assuming that everyone who's on probation fails because they didn't have the services they needed. Some people have the services and still fail. I mean, in terms of what's philosophy, I guess I'm a little taken aback by this, because while we did discuss things in our work group, and while this was always on the list as an option, I don't remember ever having a conversation in the work group about actually eliminating the custody status point. So I guess I'm a little surprised that that seems to be the main topic when it's not something that the work group really dove into, but I'll just leave it at that.
I think it became a main topic by accident today. It is not the main topic today. We're here. It's come up a couple of times, but that's not the main topic today. What do others think? What's the purpose of custody status for others?
Hi, everybody. I guess I don't have a reason why it's a purpose, but I do know why we shouldn't, why I feel we shouldn't. It feels as though it's a double jeopardy. If you're on probation or you're on parole, that is violated. That should take care of that piece of it. There shouldn't be an added half a point, an added retribution like Commissioner Larkin talked about. And really, is that what we're doing with corrections, is to punish and have retribution? Or are we looking at it in a way of how can we support these people to not commit other crimes? And I don't see, I'm just going to be honest, as someone who has been affected by this half custody point, I would be very interested to hear if anyone who ever has been affected by it has thought about, well, I'm going to get a half custody point, so I better not commit this crime, or I better not do what I need to do to survive, right? If we're thinking about it in broader terms. So I really feel like it's double jeopardy. I feel like we have enough evidence that longer sentences does not equal less crime or less it just doesn't. That's not that we're so far away from that now. We've come so far with all of our data and all of our studies that more time does not equal less crime. So
anyone else willing to tell us your views on this?
Madam Chair,
Commissioner Newton.
I'm just wondering, does it really result in any double punishment? Because the probation violation time is going to be subsumed and be run concurrently with the new crime sentence. So that's what you see. Well, we're really not going to do anything on the violation because it doesn't really matter what we do because they're already being sentenced, and the sentences run concurrent. So I don't know that there is any double punishment. And so the only additional punishment would be if there is a custody status point.
Commissioner Estrada, are you raising your hand?
Yes, I think that there's double counting as we've had it before, in that if you're on probation for a felony, you get the point for that felony when you pick up another felony or are charged and convicted of another felony. Plus, if you are on custody status, then you get an additional point. So that would be 2 points instead of 1, which then would move the box to have more jail time on your new presumptive. So it's double counting. And, in some cases, there have been situations where judges will sentence a case consecutively if they revoke the probation, depending on what that would be. But there's definitely double counting in custody status.
Commissioner Ladd.
Thank you, Madam Chair. Just a couple of things from my perspective relative to trying to eliminate the disparities in sentencing. I do think that at a very fundamental basic level, if two like individuals commit the same crime, have the same criminal history, but one is being supervised on probation because of an underlying offense, I don't think they should get the same consequence. And I think that's essentially what the custody status distinguishes, and it provides some distinctions in that circumstance. I think the other thing, Professor Fraze indicated that there were some built-in mechanisms currently in our law that would allow the courts the discretion to move within the box to give further consequences to somebody who in theory is on probation and subject to this custody status, and they could get an upper end of a box consequence. But I think that actually increases disparity, because when you look at the guidelines and you go up in the severity level, the bottom of the box, the top of the box, there is a lot of time from the bottom of the box to the top of the box. And so again, I think you would have very different sentences imposed for like defendants at the discretion of those trial court judges. And no offense to the trial court judges, but again, I think that introduces more disparity in sentences for similarly situated folks. And I also can envision, as a practitioner, arguing to the court why somebody should have a different consequence at the top of the box for something because they're on custody status, with the court responding in kind saying, well, if we should be giving some weight to that, the sentencing guidelines took it out, and now you're asking us to impose it after it's been removed. So again, I think it actually adds more disparity in sentencing for similarly situated defendants, and I think that's contrary to what the point of the guidelines is supposed to do in the first instance.
Commissioner Larkin, and then Commissioner Schnell, do you have your hand up too? Okay, so Larkin and then. I think you're on mute.
I am, thank you. And it seems like we're really discussing the merits of one of the proposals, so my comment goes to that. At the end of the day, if we were to recommend eliminating the custody status point, in addition to the concerns that Commissioner Ladd raised, we would just have to be honest about what we're doing. We're reducing sentences for everybody who's on custody status. I mean, it's a wholesale step down for every person. And how do we justify that? I mean, that's the question you need to be able to answer with the legislature.
All right, Commissioner Schnell.
So, I think, I was listening as Commissioner Ladd was talking about the custody status point and in kind of similarly situated defendants. I guess, and this is maybe a show of my lack of being a frontline practitioner, but wouldn't criminal history account for something in addition to custody? So in other words, if we were somebody who didn't have an offense, I had a previous offense, wouldn't that really be influenced? Wouldn't my criminal history score be higher because of that? Despite the fact that I have, I'm currently under supervision, and I think isn't this a little bit of what Commissioner Estrada was referring to in terms of the double count?
Yeah, that is the point that Commissioner Estrada was trying to make, that what she was saying was that when you're convicted of a prior felony, you do get criminal history points for that. And so she was saying that adding custody status is over and above that change already.
So thank you. I thought I was hearing that. The second thing I would just say, just philosophically, and I think clearly for me, it goes back to this whole question at some level around what works. If we talk about retribution or just desserts, or some of these the different kinds of frames that we might look at, why these things matter, and even the whole question about does additional time allow for additional opportunity for intervention? I think the question for me becomes what is the data say about what makes a difference? And I keep going back to this because I get concerned that, you know, the framework, the paradigm that we may have about punishment in general, and trust me, I'm struggling because there's a part of me that I feel this sense of, well, you know, you're under supervision, you had your chance. I understand that conceptually, and you know, I think in some cases I may be drawn to the fact that should fundamentally mean something, and potentially mean something of significance. And yet, when I think about what the state's objective or role is, or how that's going to make a difference beyond incapacitation, that's the part I can't wrap my head around. And so I really struggled when I think about this issue of that custody point meaning something effectively that's going to influence the effectiveness of what the state's interests are.
Okay, Commissioner Middlebrook, and then I'm going to take the privilege, chair's privilege, to do the final comment because we are sort of running out of time, and I want to make sure that we get to a discussion of the actual proposals today.
Thank you, Madam Chair. I guess the philosophical question about what does the custody status, what does it mean? And does it really make someone more blameworthy if they're on some type of custody status? I don't think that really is, it doesn't really fit into the criminal history aspect of this. It may be a factor in the case on the individual person. I think the biggest concern for me is that there's not an individualized determination for what's going on here with the person, because when it's applied across the board, it's kind of like, it doesn't seem that one size fits all here, and that you have, if the new offense occurs early on in the custody status or at the very end of it, that seems to be fairly important as far as the individuals, they're recommitting a crime, particularly I think in a lot of the drug cases where the person is an addict and the new crime is in that same vein and they're still an addict. So does that really reflect the culpability? Does custody status really fit into criminal history in that regard? Same thing with some crimes that are economic crimes that are someone's committing so that they can survive. There's a lot of factors there that I really feel that it doesn't fit into criminal history, but it may be a factor in the case when the judge is determining what's the appropriate sentence, particularly when you're looking at probation versus a prison sentence. So I guess I look at custody status where, going back to our original study on this, every commissioner then agreed that there was a problem, particularly with 1 point for every custody status, even when the crime the offense that they were on custody for was only worth a ½ point, or was a misdemeanor, or was a juvenile. And that just did not seem like it. I mean, no one agreed with that. And that still kind of carries over in looking at what our options are now when we're looking at this, revisiting and trying to decide what's the best approach.
Thanks. And I want to echo what Commissioner Schnell said, that, I struggle with this one because on a fundamental level, it makes sense that if a person committed a crime while they hadn't even finished their prior crime, that we would want to recognize that in some way and punish that more harshly. But then I think about, what are the different reasons that people might commit that new crime? And that's where I get hung up on the one size fits all approach. So I think about, many of the drug crimes and property crimes are driven by addiction. If a person is struggling with addiction and is committing that crime because of addiction, then I'm not so sure that they're as culpable because we haven't done our job to help them with that addiction. But if a person, committed an assault and is continuing to commit assaults while they're on their serving out their sentence, well then, yeah, I think that matters. And so that's where I'd struggle, with this sort of, do we have something that should always be applied, and is criminal history the right place? So it's going back to the question that Professor Fraze raised of, when is it applicable, when is it appropriate, and how much punishment does it bring with it if we decide that it's appropriate? So I thank you all for putting your thoughts on the table. I think we're all struggling with the idea, and I think we should. I mean, I think that we shouldn't be approaching this as a technical problem. I think we should be approaching this with that struggle in mind and just trying to figure out what the right policy is here. And I appreciate the discussion today. So let's just turn our attention to the ideas that are brought forth by the subcommittee. There's 4 ideas in the paperwork that you have for today. 3 out of the 4 ideas do actually retain custody status in some form. The 4th idea is to eliminate custody status. So I just want to quickly go through, make sure that we say out loud what the ideas are, and then we can have a discussion about those ideas as well. So the first one is to change this from a criminal history component to an enhancement. So take it out of the criminal history score and create a custody status enhancement instead. So it's a different provision within the guidelines. And the way that we propose that might work is that for any crimes that occur on the main grid or on the drug grid, you would, the enhancement would be equal to 10% of the presumptive duration for whichever cell they fall into, rounded down to the nearest full month. But if the current offense and the prior offense are both on the sex grid, then that enhancement would be 15%. So we're trying to, so the idea there was to mirror the fact that today custody status is enhanced if you have a current offense on the sex grid and your prior was also a sex grid. So that's why that percentage is higher. Certainly there, we can be open to discussion about a different percentage if a different percentage makes sense. But that was the idea. Now the group, the group that we, our group, since we were creating an enhancement, we put this idea together as an enhancement that always applies. So there's currently no ability in this idea to waive the custody status enhancement like there is to waive the custody status point today. But I mean, certainly that's also a topic that we could discuss if that's something that someone wants to bring up as well. So that's idea number 1. Idea number 2 is so the first idea, I just want to say, really it is more hinging on the severity of the offense you're committing today. That's what determines your custody status. So it's not as much hinged on the offense you committed in the past. Option 2, under this option, if you are on the main grid or the drug grid and have a criminal history score of 3 or more before considering custody status, then we would just add 1 criminal history point to that score. There's no half points, nothing else. It's just a simple 1 point. We originally had an idea for the sex grid that, maybe we do the same thing on the sex grid if you were at a criminal history score of 2 or more, but that ultimately didn't survive further discussion. So we decided instead to revive the old rule there for the sex grid. So what that means is that anywhere on the sex grid, if you have a current offense on the sex grid and a prior that's not on the sex grid, custody status is 1 point. Otherwise, if both offenses are on the sex grid, then it's 2 points. So for the sex grid, we're looking at the old policy for the main grid and the drug grid. This one is really getting at the repeat offender. So it is counting custody status, but it's kind of giving a little bit of time for error. Maybe that person, maybe some of those early slip-ups, maybe we give a little bit of a pass on the early slip-ups, but if the person continues to reoffend, it gets out to that criminal history score of a 3, then we're taking a different approach, and we're now putting that enhancement in place. So that's really a repeat offender kind of model. Third option is to eliminate the custody status point, and I think that that would be, if we decide after thinking about it that maybe we want to reconsider whether it should have been there in the first place. And then option 4 is really to just create a rule that allows for the sentence to fall between the cells on the current grid. And so I'm going to ask Judge Commissioner Larkin to clarify it if I get it wrong. But essentially here, if you're looking at the 2 cells that your sentence might fall between, so let's say you have a 2.5 when you add in this half point. So the cells would be 2 or 3 that you're looking at. You're looking at those two different cells. If the difference is less than a month, then you go with the duration in the cell on the lower side, so criminal history score of 2. If the difference is more than a month, then you add half of the time to the duration in the lower cell. Am I getting that right, Commissioner Larkin?
Yes, you are. I'm sorry. I was too far from the mute button.
Okay. All right. Thank you. So essentially, this one is saying, let's work with the grid. Let's work with the system that we have and just come up with a way to come up with the duration that falls between those 2 cells. So that is option 4. All right. So with those on the table, are there any comments or discussion that anyone would like to make about the different options that we've presented today? Commissioner Larkin?
I do have comments, and I would ask, can we take them one by one? It would seem that would make sense instead of people bouncing between options.
Sure. Should we start at the top?
Excellent. And I'll give my comments, and I know the work group is aware of them. I think I was probably the person that threw this out as an option because it has appealed to me, the idea that there should be a consequence, and I'm just calling it the custody consequence, and that it should be based on more of the new offense than the last offense, and that we should take it out of criminal history score. So I thought this sounded like a great idea. The reason I can't support it in its current form is because it reduces the majority of the sentences. And at the end of the day, public safety is our concern, and I just don't see now as the time to do wholesale reductions of presumptive sentences with crime where it is. So that's my concern. What I wanted to know when I was thinking about this policy in the end is if we have an offender and he's on custody status and we give him a 10% enhancement instead of giving him a custody point, how will the sentences differ? And I think, Nate, do you have the grid I marked up, and could you show it briefly so I can just point out how this looks in practice? So it would be the sentencing guidelines grid showing the 10% increase, the first document I sent.
Is that the one you sent today, man, Judge?
Yes, it is. And while Nate's looking for that, maybe I'll explain the example. I think it's helpful to see, but if we go with this 10% increase, and Nate, if you can scroll down to like assault second degree 6, perfect. So all I did here was figure out what the 10% enhancement would look like. So for example, if you're an offender who's convicted of second degree assault, a level 6 offense, and you come in with a felony criminal history score of 2 points, plus you had a custody point, what would happen is you would go to 2 to 3 points in terms of your criminal history score, and instead of getting a stayed sentence of 33 months, you would bump up to an executed sentence of 39 months. But if we go with this 10% enhancement proposal for that same offender, he or she would not cross the line from a probation sentence to an executed sentence, And instead of looking at 39 months, he or she would be looking at 36 months. That is a 10% increase over 33. So when I say that this proposal reduces sentences, that's what I mean. And Nate, is it possible for you to kind of scroll out so that folks can see the entire grid? Thank you so much. And by the way, I'm not a mathematician. I did this with a calculator. There could be a math error, but generally speaking, everywhere you see an X, a red X in the box, according to my math, that's a reduced sentence under this policy. So although there'd be no reductions for severity level 11 and 10, there would be reductions at 9 and 8 and everywhere below. So, you know, that's my concern. And then you see the same thing on the drug grid. I don't need to go through that with you. You see the same thing on the sex offender grid. And on that grid, this enhancement, this 10% enhancement, would essentially result in reduced presumptive sentences for every offender except offenders at the most serious level, A and B, with criminal history score 0 to 2 or 0. And then where it's really problematic, at least in my view, is when we're looking at those offenders who are in custody status for a sex offense and they create a new offense that's a sex offense. Because under the current guidelines, those people get 2 custody points. And Nate, could you go to that last grid I sent you, which shows the 15% increase? Is that it? That's it. So for example, here's my concern. So let's look at level D, which is a 2nd degree crim sex. If a person is on probation for crim sex 2 and they had 1 criminal history point without a custody status point. Okay, let's say they now commit a new crim sex offense. Under the guidelines, they would get 2 custody points. So they would go from criminal history score of 1 to 3. They would go from a 48-month state sentence to a 70-month executed sentence. If we instead apply option 1 and just give them a 15% enhancement over their 48-month presumptive sentence, they're ending up on probation with 55 months instead of in prison with 70. So I guess all I'm pointing out is, even though it might sound like, oh, 10% enhancement, 15% enhancement, there's a consequence, we just need to understand that in the end, the presumptive sentences are going to be reduced for like 80% of the people. So, you know, when we explain this to the legislature, we need to say, okay, we're going to do this. We're still having a consequence, but we're reducing the consequence for a whole lot of people. And that's just something we need to be able to explain. So I don't support this. I think if we could come up with a different percentage that would keep sentences where they are, but I don't know how we do it when it comes to sex offenders who are on probation for a sex offense and commit another sex offense, because I started doing the math on that, trying to figure out, you know, what's the percentage increase in these steps, and it's all over the board. And I just gave up because I thought there's no way we can come up with something other than 15% that replicates the 2-step process that is currently in place in the grid. So, I mean, I think this is a good concept, but what we have now, in my view, just reduces sentences too much.
Let's see. So I think Commissioner Middlebrook and Commissioner Estrada are raising their hands.
Thank you, Madam Chair. Commissioner Larkin, I guess I'm confused on you're saying that this proposal reduces sentences. I guess I'm confused on that because if our point is that we're trying to figure out the custody status and how it should be used, you're projecting that it's going to reduce sentences in all these cases, but it also depends on what the new offense is, as well as, where it lands on the grid. So I guess I'm really confused on how you're projecting that it's going to reduce sentences, because they're all going to be future and they're going to be off the grid with that enhancement. So it would be where they land on their criminal history plus the enhancement for a custody status. So I guess I'm just confused.
I'll try to make it as simple as I can. We'll go back to the first example. If someone is pending sentencing for assault 2 and they come into court with a criminal history based on felonies and misdemeanors, not custody, of 2, they're presumptive. And now let's say they also would have a custody point. So that gives them a criminal history score of 3. That person's presumptive sentence on the grid would be 39 months executed. If we say, okay, we're not going to give you a custody point, so that results in a criminal history score of 2 instead of 3, we're instead going to give you a 10% enhancement of what you would get at criminal history score 2, the person ends up with a 36-month stayed sentence. So that's what I'm saying. At least when it comes to whole points, anytime you say, well, you're not going to get a custody point where you would have had one before, you're dropping back to the box on the left. And what I'm pointing out is when you look at what that 10% enhancement results in, it's always going to be less than the box you were originally in with the custody point. And in some instances, it's going to result in people getting presumptive probation instead of presumptive commit. So when I say that's why these sentences are going to be reduced, I get it. This is a very, elementary approach I've taken. I'm not a statistician. I'm not on Excel. I'm doing this with, pen and paper. But it seems like if you just start looking at the numbers and pick any box on the grid and say, well, if it's ag robbery first degree, it's a person who's a criminal history score of 3 based on felonies, and we give them a custody point, they're at an 88 commit. Well, if instead of giving them a custody point, we give them a 10% increase of where they are without the custody point, they get an 85-month sentence. That's a reduced sentence. And as best I can tell, every box with an X on these grids that I've submitted results in a reduced sentence of one form or another. It might only be a couple of months. It might be 8 months. It might just be the number of months and not the disposition. But anytime you're at the bold line and you take away the custody point, somebody is going from presumptive to commit to presumptive probation. That's a reduction in sentence. It necessarily happens when you take out the full custody point. Does that explain it?
Thank you, Madam Chair. Yeah, that explains it. I guess I'm still having, I guess it sort of goes back to what is our goal here? Are we looking at, trying to improve how the custody status is used? And if that, it seems like all of these, there's going to be a reduction in sentence from what it is right now if we change the custody status. And it seems like your premise is that we should stay with 1 point for custody status. So nothing here, there's no reduction going, forward into the future. I guess that's where I was confused about that.
I should clarify. I am not saying we should increase sentences, but I don't want to decrease sentences. And that's why I came at the last minute with the proposal to simply fix the problem with we have and define what a half-point increase would look like.
Okay, so
I mean, philosophically, you can say, well, we don't want any consequence for custody. I don't agree with that philosophical position. I think there should be some sort of custody consequence. And although I originally thought taking it out of criminal history made sense and that doing it as an enhancement makes sense, I'm just saying I don't support that method, because when you actually look at how this plays out on the grid, we've got too many sentences being reduced and too many people moving from one side of the line to the other. and I think what the concerns you're raising are different. It's like, I don't think you can argue that this proposal reduces presumptive sentences for a whole lot of people. And you may say, well, that's fine. We don't want the custody status point. But that's just a different position. You can't argue with the facts that if we were to recommend this to the legislature, we'd have to say, oh, and in doing this, please note, sentences are going to be reduced across the board for most people.
Okay, so with time running out, this is what I'm going to propose. Commissioner Estrada's been waiting to speak, so I'm going to let her talk. And then what I'd like to do is just open it up to see if people have questions about the specific proposals so that we can clarify any proposal, any questions people have about those. And then next meeting, I think we bring them back probably with language and how they might function. And we can have a more in-depth discussion as we're starting to right now about this sort of pros and cons of each approach. Commissioner Estrada.
This is just a clarification question. Judge Larkin, am I understanding that your concern is more of how many different offenses would have a reduced sentence, or are you completely against any reduced sentences? And I asked that because obviously with half a point, there were some stipulations of who gets half a point, who gets a full point. So obviously people who are getting half a point are getting reduced sentences. And that was a change that the 2018 commission did. So there was a reduction there that we submitted to legislation, and that was understandable. Are you opposed to all sentences reductions, or just in this proposal, the amount?
I guess I am opposed to reductions. And I think, I mean, I got to think through. I think the solution the commission came up with the half-point solution was a good one, because I completely agree. Someone's criminal history score should not be enhanced more by the mere fact of custody status than it is for the offense that put them in custody status in the first place. So I agree with that. And I think, you know, if we're going to just throw it all out, I'll just tell people and then I'll be quiet unless people have questions for me. I think the best proposal is simply to fix the problem that was created when the commission did a good thing, which was to reduce criminal history by going with the half point. I think that was a good thing to have done. I think we should stick with it. And I think we should just fix the resulting problem, which is we don't have any presumptive sentence boxes for half-point scores. And I think it's very easy to correct that by just doing new grids that reflect half-point scores and give people a proportionate, objectively defined bump if they have custody status, and that custody status results in their having a half-point score. Because there's no other way to make the half point work. The reason I spoke against the rounding down rule is if you do that, then not everybody who has custody status is being treated equally. If you're at a 3.5 and you get a half custody point, you get a consequence resulting from your custody status. If you're at a 5 and you get a half custody point, it has no impact on your sentence. That doesn't seem right. So I was just trying to come up with a solution that honors the reduction that got us to the half-point custody status while giving some consequence that is commensurate with the half-point status that applies to everyone equally on the board. And I fully agree and share the concerns about these really should be individualized determinations. And this does seem like an area where one size does not fit all, but you know, in guideline sentencing, one size fits all unless you get to departures. And it's my understanding that the commission previously looked at making custody status an aggravated factor, and reasons were given that went against that. Specifically, we don't have the resources we need to have jury trials to supervise people on probation. Do we now want jury trials or even contested evidentiary hearings about why somebody was or wasn't successful on probation and how that should factor into sentencing? It seems like that just makes it much more complicated than it needs to be. So, I mean, just to sum up, I like the idea of just saying, if we're going to have half-point scores, let's just have a grid that accommodates them in a way that's proportionate and fair, that honors the work of the commission that came up with this proposal 2 years ago, that does not change the way we deal with custody status, which means we don't have to rewrite the guidelines, we don't have to re-educate the practitioners, the bench, and the probation officers. All we have to do is give them a new grid that they can use in these circumstances. And then every offender who has a custody status will receive a custody consequence that's commensurate with the offense, without reducing presumptive sentences for anyone. So that's what I think the best solution here is, especially with this timeline. I mean, I'm a little frightened of the notion that, you know, the commission took 2 years to talk about all of this, came up with the half-point solution, and now in 2 months, we might drastically change it, including going to a no custody status point, which is something we've never had in Minnesota. Even before the guidelines, we had a custody consequence. To say that, you know, in 2 months, we're just going to do that, that's such a major change. I don't feel like we've had the time to digest that change.
All right, are there any questions that commission members have about any of the options that are before us? Okay, so we're going to continue the conversation next month. We'll dig into all of them. We'll have more time to dig into all of the proposals next month. But thanks for the conversation today. Nate, do you want to move on to item 8? Do you feel like you have time for that?
Sure. So 8 is Robinette, is that right?
Yes.
Okay, so I actually started to show the screen, so maybe we'll wait. Not what I wanted to share. Okay, so this is a case we've kind of been waiting for a while. It's interesting because the author is now a member of the commission, and the dissent is the person who appointed the author to the commission. So I think that's kind of an interesting dynamic. So we were introduced to the common law amelioration doctrine. I was introduced to it. I guess it's been around for a long time, but hadn't really, that phrase had not entered Minnesota jurisprudence until 2016 when State versus Kirby came out, and that had to do with the sentencing guidelines as well. And what the amelioration doctrine says, as Kirby articulated it, was that an amended criminal statute applies to crimes committed before its effective date if 3 things are true. One is there's no legislative statement clearly establishing an intent to abrogate or not follow the doctrine. Second, the amendment mitigates punishment, and that's what happened in 2016 with the drug offender, with the Drug Sentencing Reform Act. And third, that for this particular case, the judgment isn't final when the amendment took effect. So that's different from how criminal laws normally happen. Normally, a criminal law is effective for crimes committed on or after the effective date. But this could apply even to crimes committed before the effective date, as long as judgment wasn't final. So in 2019, when the commission made a bunch of changes, which we've already discussed, they tried to abrogate the amelioration doctrine, and the Supreme Court said, nice try, but the legislature and not the Sentencing Guidelines Commission must abrogate the amelioration doctrine. So what are the impacts of that? Well, this slide, which we've already looked at briefly, shows all the 2019 criminal history score changes. And these are all really in the nature, I would say, of mitigating changes. The decay changes shortened the decay period for some felony offenders, all misdemeanor offenders. The custody status point changes, all of these are again mitigating. The half point was created. Some eligible statuses were repealed. They no longer apply. And in some cases, judges were permitted to waive the custody status point. None of those things were true before August 1st of 2019. So what Robinette appears to imply is that these changes don't just apply to crimes committed on or after August 1st of 2019, but they apply to all crimes that are still in the pipeline. So as a consequence of that, what staff is doing is we're working with the IT staff at Department of Corrections to update the electronic worksheet system so that pretty much any worksheet that's going to be created going forward is going to apply these changes that are shown on the screen. So that's the electronic worksheet system should automatically take that into account. What are the implications for the commission's work? Well, I guess my question to the commission is, do you want to change 3G? Because 3G, particularly 3G1, which isn't really true in light of Robinette, right? What 3G1 says is that modifications apply to offenders whose date of offense is on or after the specified modification effective date. And now there's a big asterisk unless the amelioration doctrine applies. And then modifications might apply before. So instead of just, I mean, it was very simple. You knew which guidelines were in effect. You just look at the offense date and you pull those guidelines off the shelf. Now it's not quite so simple. It depends on whether there were ameliorative changes that were made after that. So that's something to look at going forward. Unless there are any questions, Madam Chair, we can move on to the next agenda item.
Does anyone have any questions on that? Or any comments? Okay, well, we'll just let's keep thinking about that one. Go ahead.
Okay, and then the next agenda item, the next agenda item has to do with, well, the next two agenda items have to do with things that the commission wanted to look at after the July meeting. The commission said, okay, we're going to make these decisions, but we'd like to look at some more things on this. One has to do with the severe violent offense list. I've provided in your materials, really the only thing the guidelines, I mean, I think it's already been indicated previously in this meeting that the December 2018 package that was, or I guess, was it October? But the package that was adopted in late 2018 was really a package, and it kind of came out of a lot of discussions. I don't know that it was ever articulated what exactly the criteria were for inclusion on the severe violent offense list. This came up in July when there were a couple of new offenses that maybe should or shouldn't appear on that list. And the commission said, let's take a look at that. I've included in your materials the comment in the guidelines that really is the sum total of the commission's official expression of what the point of the severe violent offense list is for. With respect to agenda item number 10, if I may move on, Madam Chair, unless there are any questions. So treatment of sex offenses divided in 2021 by adult and child victims. There was some interest in discussing this further, and we haven't done an exhaustive literature review. I don't know that we have the abilities in-house to do that. We'd probably have to try to make a trek to Wilson Library or something and see if we can do a more exhaustive literature review. But we did find a source that it's a very recent article, and it does do sort of an analysis of how dangerous are offenders who commit sex offenses against children versus offenders who commit sex offenses against adults. I think those findings seem to be pretty interesting in terms of the commission's decision. It's kind of a mixed bag. It appears that people who commit sex offenses against adults are actually in some ways more dangerous in terms of aggression and antisocial personality disorders and so forth, and committing dangerous offenses in general recidivism. But people who commit sex offenses against children are more dangerous in terms of committing future sex offenses. So it's a mixed bag, and I don't know how helpful the literature is going to be, because I don't know that I think they're probably just looking at sex offenses against children in general, including what we call age cases. And really the question that's before the commission is, based on the legislature's decision to take non-age cases and divide those between victims who are children and victims who are adults, is that something that the commission should take a look at? You know, should we treat these differently now that the legislature's made this distinction? So it remains a thorny problem, and we'd be happy to look for direction on how you want staff to continue on this. But I know that you were interested in information on recidivism. We've at least provided some to you. I don't know how conclusive that is.
All right, and so those 3 items that you just went through fairly quickly are items that are going to continue to be on the agenda, because we need to continue those discussions and sort of resolve we kick the can down the road in making our ranking decisions, but we need to sort of resolve those policy issues ultimately. Is there so okay, that's all I've got. Do you have anything else on those items?
No, Madam Chair.
Okay, great. Your executive director report.
Madam Chair, you already took part of it, which was that we are going to be publishing the guidelines next week, so taking care of that. The only other thing I just bring up to the commission's attention is we do record these meetings. We do have a YouTube channel. It would be possible for us to put these meetings up on YouTube. We've never done that before, but there's certainly plenty of state agencies that do put their public meeting. I mean, obviously it's a public meeting and they do put their public meetings on YouTube. I just didn't want to do that without at least running it by the commission first. So I don't know if you want to think about that or get back to me or you know, maybe that's just a conversation you and I could have, Madam Chair, but just wanted to throw it out there. There's at least something that's come up in staff conversations.
And I think you frequently get asked for recordings by the media, I think.
We do, right. Just because it's not on YouTube doesn't mean we've never put out those recordings to members of the public, usually media, not always, but yes, you're right, Madam Chair.
Commissioner Larkin.
Thank you, Madam Chair. In the interest of transparency, I think we should absolutely put these meetings on YouTube if we can. When I talk with people about the commission and the work we're doing, you know, they're very surprised. I don't know that a lot of people know about this group and what we do and how important its work is and the major changes it can bring about. So I think our meetings should be available to the greatest extent possible. And if we can do that by putting them up on YouTube instead of requiring someone to request a recording of the meeting, I think we should do that.
Yeah, I don't have any objection. Are there any other commission members who have a thought on that? Commissioner Moore?
Thank you, Madam Chair. I would support what Commissioner Larkin's saying. I think more transparency regarding this would be good. I think it would be an excellent idea.
All right.
Madam Chair, I would concur as well.
Great. I think the one good thing the pandemic has done is bring greater transparency to all of our public bodies, because it's actually sort of forced us into the electronic age too. So yeah, I think that you have your answer. You can go ahead and post them.
Okay, thanks, Madam Chair. We are short-staffed right now. We might not. And I should say, I mean, we might
Sure.
not right away. We might take a little while implementing that, but thanks
Sure.
for the guidance. I should say also, it's sort of dependent on us having hybrid meetings or WebEx meetings, because those are the ones, all I have to do is press record, which this is the first time I've sat in this chair, so I didn't press record until a few minutes into the meeting, but most of this meeting, almost all of this meeting is recorded. So, but that's not necessarily true if WebEx is not on.
Yep.
That concludes my report, Madam Chair.
All right, thank you very much. Last item on the agenda is public input. I'm not sure if we have anyone else on the line, but I'll turn it over to whomever is going to guide us through that piece.
All right. Okay, members of the public listening remotely, in a moment, your microphones will be unmuted. If you do not wish to make a comment, please remute your mic to reduce feedback. If you wish to make a comment, please state your name and the chair will call on you. Attendee list. I don't know. Haven't done this before, Madam Chair. Can't get the attendee list to pop up. Oh, there it is. All right, I am now unmuting your microphones.
I will speak. This is Kevin Beverly. I wouldn't normally speak in a public hearing, but I am all for you going on YouTube, folks.
I'm sorry, did somebody, I couldn't quite hear that. Was there someone talking?
That was Kevin Featherly. Can you hear me?
Yes, I can.
I apologize. I wouldn't normally speak in a public meeting, but you're addressing an issue that is of direct importance to me. I would vote yes for YouTube. That's all.
All right, thank you. Any, looks like everybody else has muted their mics. Am I seeing that correctly?
Yes, Madam Chair, that's how it appears.
Okay. All right, so that concludes our public comment session. So that's it. The next meeting is sometime in October. I don't remember the date, I'm sorry. But that concludes our business for today. As I mentioned, we are going to continue working on the partial point issue next month. So please take a close look at those proposals. We'll be providing, more updated information about those, but start to think about, which one seems to make the most sense to you, both philosophically and in terms of the goals that you think we should be achieving with that in the guidelines. And we'll definitely have that discussion. And then we will continue to discuss the items 8 through 10 that are on our list as well. We'll have to sort of, if I'm prioritizing, I do want to try to prioritize the partial point issue and make sure we get that done. But I also want us to complete those other discussions as well. With that, thanks all for the discussion that we had today. I really appreciate everyone coming prepared to talk about these items and really, indulging me in taking it to a bit of a philosophical level today. I do appreciate that. With that, the meeting is adjourned. Thank you. See you next month.